Tune in. Let me make sure I'm on Wi-Fi. Can you guys on TikTok see me? It says I lost connection. Let me know if you can see me on TikTok. Hi, everybody on Facebook and YouTube. Hey, guys. Hi, everybody. Welcome, welcome. As you're tuning in, definitely comment in the box. Say hi. Let me know where you're tuning in from. And I would love for you to hit that share button and share it with your friends so they also can tune in and learn some stuff about immigration. I'm going to be answering your questions today. Wow, AJ, thank you so much for tuning in from Germany. I know it's probably evening time there, is what I'm thinking. Everybody on Facebook, hi, comments and let me know where you're tuning in from. Those of you on YouTube, comment and let me know where you're tuning in from. Let me introduce myself. For those of you joining for the first time, my name is Aisha Chidoli. I'm an immigration attorney. I serve clients in all 50 states in the United States with their family immigration matter. Immigration is a federal law, so location doesn't matter. I have clients all over in probably about 40 states in the United States, so it doesn't matter. Good morning, favorite Harry on Facebook. Oh, hi on TikTok from Nigeria. Welcome. Colleen, welcome from Florida. I'm also in Florida, sunny Florida. It's super hot, even though it's been raining a lot in the last few days, but the weather is nice. And as usual, as always, especially if you're new here, I love to answer your immigration questions. So feel free to put them in the comment box. I would try to answer as many as I can once I finish talking about my topics. Today, I really just want to talk about a fiance visa basically versus a spousal visa. What the differences are and what the disadvantages and advantages are. So, I get a lot of calls. Hi, Elias from Dallas. Thanks for tuning in. Sandra, I see a question. I'm going to go back and read it once I finish this and try to answer it. So I get a lot of questions. Favorite Grace says, good morning to the best immigration lawyer. You guys are so great. Thank you so much. You guys are the best audience, the best viewers, the best hype people ever. So as I was saying, I want to talk about, fiance visa and spousal visa. Another word for spousal visa, for those of you who don't know, spousal visa just basically means that means a green card through marriage. It's just that you get it when you're outside of the United States and you're coming into the United States. So that's why they call it spousal visa. In America, it's called adjustment of status. But when you're outside, what you get is a spousal visa that essentially converts to a green card once you come into the United States. A fiance visa, I'm sure you guys all watched 90 Day Fiance, or you've probably heard of it, unless you live under a rock. So you know what that is. So a fiance visa is basically exactly what it is, a 90-day visa. And a fiance visa is given only to the fiance of a U.S. citizen. So if you're a green card holder, you cannot apply for a fiance visa for your fiance. You have to be a U.S. citizen to be able to apply for your fiance. Okay, that's the first thing. The second thing is that they want to know that you've seen that fiance of yours within the last 2 years, at least once within the last 2 years. Of course, with many things in immigration, there are always exceptions. So the exception is if it poses an unreasonable, burdensome process for you to see that person. So last year would have been a great example, due to COVID-19 and borders being closed, due to the virus. That would have been like a good excuse, because it would have obviously unduly burdensome, because borders were closed. You don't know if you go to another country, if you're going to be stuck there, right? Because whole countries were closed. But generally, they want you to have seen your fiance at least once in the last 2 years. The other requirement is that you have to still show that you meet the income requirements to sponsor that person as a fiance. Okay. And what that means is, normally when you're filing for your wife or your husband, you have to meet the income requirement. The income requirement when you're filing for a marriage is a little bit higher than the income requirements, for Fiance Visa. So it's like 100% past the poverty guidelines for Fiance Visa and 125% past the guidelines for, a marriage-based case. Now, now I'm going to talk about the requirements and the differences between them. Okay. So generally, if you come into the United States with a Fiance Visa, listen very carefully. All of you that are engaged to U.S. citizens or in the process of filing a Fiance Visa, listen very carefully to this because this is very important. If you get a Fiance Visa and you come into the United States, you need to marry that spouse that brought you into the United States. Not only do you need to marry them, you need to marry them within 90 days. Keep in mind that visa, it's also called a K-1 visa. It is a 90-day visa. Okay? So if you don't marry them, and let's say you still marry them, but you don't marry them within the 90 days, you're going to have to do your whole application all over again. So that is one of the things about not marrying them within the 90 days. Now, the worst case scenario is that if you don't marry them at all and decide, all right, peace out, I'm in America, I don't love you, I'm moving on, I'm going to go marry somebody else, you will never be able to adjust your status in the United States. Let me repeat that again. If you do not marry the person who brought you here on a Fiance Visa, you will never be able to get a green card while being in the United States. Should I say that again? Or are you guys hearing me loud and clear? You will never be able to. So you need to make sure that if you come here on a Fiance Visa, that you marry the person, okay? You marry the person. Again, if you marry them and it's past the 90 days, you still have an option. You just have to start the whole process again. But if you don't marry them at all, you won't be able to adjust while in America. You're going to have to go back to your home country if you marry somebody else, after you get approved for a hardship waiver. So that is the big difference between that and a marriage-based visa. So the marriage-based visa, which is also a spousal visa, means that you're already married and you're doing what we call consular processing. Consular processing means that you're doing half of the application in America. Once they approve this half for either the U.S. citizen and the green card holder, oh yeah, that's another major difference. With a marriage-based case, a U.S. citizen or a green card holder can file for you. You don't have to be, a U.S. citizen. That's only for K-1 students. And guys that are just joining, welcome. Again, please feel free to put your comments in the comment box. I will try to get to a bunch of them as much as I can once I answer once I finish the topic that I'm talking about. So, with that spousal visa or marriage-based visa that leads to a green card, once they approve your spouse, they approve them, and they can come here. So once they come here, they're getting their green card, they're ready to work, and that's the end of it. If you go the K visa route, they still have to go through this process to be able to work, to be able to do all those things. So, when people come to me and say, well, which one is better? The answer is that it really depends on your personal family lifestyle or your own personal family relationship. And what I mean by that is that there are a lot of immigrants who support their family. There are a lot of immigrants who support their family members, okay? And those immigrants having an employment gap might be rough for them. Like having to come here and wait several months, like let's say they came here on a spousal visa and they had to wait several months, to get a work permit while they're waiting for their case to be approved. It might be rough for them if they support their parents, if they support their siblings, if they support other children. Okay, if that's not an issue for you, then by all means come with a K visa. Prior to the pandemic times, it was taking K visas or Fiance visas where it took a shorter time to come to America than a marriage-based green card. Now it's just really a tuss-up because, so many embassies, so many consulates have been closed due to the pandemic. So there's just a backlog for everything. So that's what it is. If you know that you need to be able to make an income and that you're making an income in your home country already, and that you coming here and not being able to work, not being able to support your family is going to be rough, then do the, marriage based. If you do the marriage based, at least, the minute you arrive, you'll be eligible to work. So those are some of the things that you want to consider, when you're doing the two. With the marriage-based visa, if you come into America and you come in with, if you get a conditional green card, similar to getting a conditional green card in the United States, you're going to need to remove the conditions in your green card after at the 2-year anniversary. Okay, you and your spouse. If you guys get divorced, you can still remove the conditions. You just have to show proof that your marriage was real and you entered it, truly, not because of, just coming to America. And then if you enter with a 10-year visa, then you're good. You're good. You can work. You don't have to remove any conditions. You can, file for citizenship at the 3-year mark with your spouse or 5-year mark with your spouse. So that's that on K1 fiance visas and spousal visas. So that's the difference. And so, the benefits really depend on you and what, works for your life. All right, guys, I'm going to take some questions now. So let's start with Facebook. So somebody says, hi, how are you doing? I have a question. My father lives in Florida. He has a green card. He has 3 years on it. He's a nursing home. Can I apply for citizenship and what step can I take? Please tell me. Well, Sandra, the answer is that it really depends on how your father got his green card. At 3 years, if your father didn't get his green card through marriage, he's not going to be eligible to file for his citizenship. He has to wait till he's had his green card for 5 years. If he got it through marriage, then he can file for 3. If he's been married for 3 years, he's had his green card for 3 years. And he has to file it, and his wife or spouse, I don't know, like assuming he's married to a woman, she has to be present, for that process if he's doing it at the 3-year mark. If it wasn't through marriage, then he's going to have to wait 5 years before he's eligible. Okay. Favorite Grace says Jamaica in the house. Hi, nice to have you here. What part of Jamaica are you from? I love Jamaica. I got married in Jamaica, so it holds a very special place in my heart. Let's see. I have some on TikTok. Let me just see what's going on here. I haven't received my second update for K. It's been 6 months. What can I do besides emailing? Unfortunately, there's not really much you can do. It's like what I just explained. Right now there's a delay. I don't really consider 6 months a long time, believe it or not, in the world of immigration right now, just because of what has happened in the last year and the backlog. So, when you say your second update, it's a little bit vague. You can definitely call me so I can understand what phase you are in the process. Have you done this phase in the United States? Has that been approved, or are you the beneficiary? So the question is a bit vague, but generally 6 months is not something that I would consider a long time in the world of immigration. Somebody says, Markinson on TikTok says, in November, it's going to make 5 years. I'm assuming you mean since you've had your green card. So can I start my citizenship process now? I will wait 90 days before November, August, September, October. So that should be somewhere around August. So I will wait till August, right? Am I doing my math correctly? Basically count 90 days prior to the date in November. That's the earliest, you want to file for your citizenship. Okay. All right, let's see. So Raquel says, I'm an H-2B worker, and I did a change of status for a B-2 visa because of my pregnancy. My baby was born premature a few weeks ago. Oh my goodness. I hope your baby's doing better, and congratulations on bringing a a child into the world. My baby will be in the NICU for a while, so I cannot travel back to Jamaica. My daughter requires a lot of medical care, so I need to apply for a green card. What is the name of the application I fill out? Okay, so you can apply for a green card just because your daughter is, I know it's really sad that your daughter is in the NICU, but that wouldn't qualify you for a green card, unfortunately. So there's no application to fill on the site. What you can do is you can look into a medical deferred action. And what a medical deferred action, for those of you tuning in, or don't know what it is basically like if you have a family member, like an immediate family member that is very sick, and you can show proof that moving them, first of all, one, that they're not capable of taking care of themselves and they need somebody to take care of themselves. In this case, this is obviously an infant who needs their mother to take care of themselves. You can ask your local field office for medical deferred action. And what that means is that they will allow you to stay temporarily, sometimes usually about 2 years, a year, depending on what it is, and allow you to get a work permit while you're taking care of your child. You have to show proof, though, that your child is in this NICU, how you're going to take care of your own expenses so that they won't say that you're going to be a burden. And so having the doctor's reports, having a doctor's prognosis, having a doctor sending a letter basically saying that how long this child needs to stay there here, and it's a risk going there, looking at your country conditions, and if the kind of medical issue the child has or the person has, if it's something that the prognosis for recovery or healing is high where you're from. If you're from a country where the medical stuff is not good, then you have a better chance for approval. So that would really be your only option really right now at this point, unfortunately. But I do hope your child feels better, okay? All right. Oh yeah. And then, as we've mentioned, I'm sure in the last few posts, anybody who signs up for any of their immigration cases with us between now until July 2nd, you get 10% off of any of your payment plans that you select. We're doing this for 4th of July to celebrate America and celebrate your journey to become an American citizen. So definitely call us if that's something you're interested in. Okay, Favored Grace said that she's in Kingston, Jamaica. I actually got married in Negril, Jamaica. So Sandra, right before you, let me just get some people on TikTok. If the income requirement is met, should I have additional minimum amount of money in my bank account? So I mean, if you want to, I mean, it's always good to have money in your bank account. But really, when they're looking at income for fiance visas and marriage-based cases, it's not necessarily that they're looking at your bank account to know how much you have. Like, they've removed certain of those rules now. It's more so to make sure that the person earns an annual income that is livable for them to be able to support that person that they're sponsoring. That's what it's for. But of course, you should always have money in your bank account. The more you have, the better for you. So somebody says, I have a 10-year visitor's visa, but my spouse is an LPR. For those of you who don't know what LPR means, that means legal permanent residence. Should I go to the USA and marry him there or Jamaica? Well, I can't answer that question for you. You have to decide what is best for you. If you're just tuning in, you will see that I just talked about what the differences are. So you have to decide what is better for you. If you do come into the United States and you end up marrying your legal permanent resident spouse. What that means, for those who don't know, again, is that a green card holder. If you do marry your green card holder, it's not going to matter whether or not you have a 10-year visa. What is going to matter is that between the 6-month stamp that you're given once you come into this country, that you've married the person, and that you filed your application for adjustment of status, as long as a visa is current. Because Yeah, in the month of June, visas are current. I don't know what it's going to be in July. I don't believe they've released it yet. It's possible it's going to be current as well. So those are all things that you need to make sure you evaluate before you come. And I do not recommend getting married, coming into the country and marrying somebody in under days. Why don't I recommend that? Because there's a presumption of misrepresentation to USCIS or Customs and Border Patrol. And so you're going to put yourself in a bind or put yourself at a raised level of scrutiny if you do that. So you do not want to marry somebody once you come into the country. You come in August, you get married to the person at the end of August or in September. Don't do that. Okay. Sandra says, Aisha, he got his green card from 2005. Him and his wife are not together. Can I do the citizenship for him, even though he's in a nursing home, or I have to take him out and let him live with us? Honestly, it really just depends on your father's coherency, Sandra. So if he got his green card in 2005, is well over 20 something years, so he's eligible. However, once you're age 83, there's certain exceptions that they make in terms of the civics test. You're going to have like an easier civics exam, but your father needs to be coherent to take that test. You can't just apply for him. He has to apply for himself, meaning he needs to sign it. If your father is not capable of signing it, then the odds are that he will not be capable of attending the interview and passing the interview, because he still has to attend that interview. And they still have to see 3 months of residency in a location before he can file it. So if your dad is coherent and he's able to file it, he needs to be signing his stuff himself and submitting it, and he needs to be able to study they give them just like a shorter amount of questions to study from, that makes it easier for them, but he would have to still take that, okay? Unless he can show, that he has like a learning disability or something. Favor Carey says, when a prima facie expires, do you reapply, or they will send you an extension automatically? So they generally will send you an extension automatically. So Angelica says, what does it mean when USCIS said they sent out a duplicate notice about a decision on your Form I-485? So this doesn't sound good. So if you get something saying that we sent a decision on your I-485, I hate to be the bearer of bad news. It usually means that you've not been approved. If you were approved, it will specifically say that we've approved you for your Form I-485. So I'm hoping that you're talking about something else, but that is what that means. Somebody says, when do you recommend getting married after you come into America? Well, definitely not within 90 days. Obviously you pick your own timeline. I can't recommend a timeline for you and your spouse. You have to decide that, but you definitely don't want to do it within the first 90 days because of what I said. There's a presumption of misrepresentation, So Zobia says for K1 visas, 9 months is the average time frame. Not anymore. That used to be 7 to 9 months. Now it's like 12 to 15 months, honestly, because you don't even get your I-129F approved for like 7 months. By the time you then go to NVC and you do that, get back on the consular line, it could take a long time. So 9 months honestly is a pipe dream. Is it possible? Maybe if the country doesn't have a lot of people applying. It depends on the country, but if it's a country where people are applying, that's a pipe dream. It's going to take you a little bit. Okay. So Elizabeth says, please read my question. Elizabeth, I don't know, can I find it? Let me see if I can find you on here. Elizabeth, can you just ask your question again? Sorry, I'm like putting my fingers on the screen. I can't find the question. You can definitely ask it again. Okay. Can you ask your question? I think I lost my stuff. Guys, just hold on 1 second. Let me try and see if I can fix this stuff on TikTok. Okay, so yeah, ask your question again. I lost my filter. I gotta get my filter on. Okay, so let's see. Sandra says, I have a 2-year green card. Can I file for my kids in Jamaica? One is 21, Jamaica. One is 21, 22 or 20, whatever, 22, and another one is 26. Okay, so in order for you as a green card holder to file for your children that are over the age of 21, as a green card holder, they have to be unmarried. So that's the first thing. So that 22-year-old and 26-year-old must be unmarried. That's the first thing. The second thing is, as a 2-year green card holder, you can petition. However, you better be darn sure that you will be approved to remove your conditions on your green card. Because if you're not going to be approved for that, then your kids are not going to be approved for the petition. There is going to be a wait because your kids are over 21. So right now, I believe it's about 5 years. As of June, it's about a 5-year wait for children over 21 when you're a green card holder. You know, and it's funny because children over 21, if their parents are U.S. citizens, it's like a 6-year wait, and then it's 5 years for green card holders. It's shorter for green card holders. It's weird. Okay. So Shawanda Johnson says, I'm filing for my husband's conditional green card soon. Must I change my last name before filing, or can I file with my maiden name? I have legal licenses and can't change my name yet. It's up to you. You know, if you've not legally changed your name, then just follow whatever your legal name is today. That's just what it is. Somebody says, my husband came here for a work program from Jamaica. His work visa has expired. Can I still petition for him for a green card? So Nikki, it depends on what is your own status? Are you a green card holder, or are you a U.S. citizen? You know, that's the first question. And then the second question is, what kind of work visa did he come on? You know, H-2B, J visa, what is it? So let me know, okay? Okay, somebody says, okay, Elizabeth, I see the question now on TikTok. My friend is a small business owner. Can she seek a green card for her business? Okay, so so let's talk about this and getting a green card based on you owning a business. So in order to get a green card based on owning a business, you have to show that you have either $800,000 or $1.8 million to invest in the United States. So that is the first thing. And if you have that, if it's $800,000 and you're willing to work in an area where there's a lot of job scarcity, like in a rural area and stuff like that, you know, all you need is $800,000. If you are in like a popular area and stuff like that, you need to have $1.8 million. That is the only way you get your green card, through you owning a business directly. Now, there are other options. I'm going to talk about them, but nobody better start calling me for business immigration, because I don't handle business immigration. I just happen to know a lot about it. So the second option is you can get an E2 visa. An E2 visa is not going to give you, it's not going to give you a green card, but it's going to allow you to stay here as long as you continue to, be in that business in which you got the E2 visa for. And E2 visa doesn't have such a high requirement. With E2 visas are basically visas for people that are part of what they call the E2 treaty countries. So if your friend is from an E2 treaty countries, or if they want to find out that they're from an E2 treaty country, they can just Google, E2 treaty countries and check a list of the countries. If they're listed on there, then they can apply. But keep in mind that your friend can be an overstay though. If your friend is already here and has overstayed their visa, they won't qualify. Remember, it's only family-based cases when you're married to a U.S. citizen, or your child or parent of a U.S. citizen, that they forgive that. But otherwise, if they're already here and they're overstayed, they're not going to be eligible for any of that. Hi, Shelly. Simon says, good morning. Thanks for tuning in. Hi, Kogmotsu. We're going to slam dunk your interview tomorrow. Okay. Yeah, so that's the answer to that question. Okay, Nikki, so you're a U.S. citizen. So you're a U.S. citizen, and this is Nikki, the one who asked the question about her husband being here on a work visa on Facebook. So I know you say he has a work visa, but a work visa is very vague. So does he have an H-2B or J-1? If he has an H-2B and you're a U.S. citizen, you can certainly petition for him. Remember, again, you want to make sure that it's not, he's been in the country for more than 90 days. So that's the first thing. The second thing is, if it's a J-1 visa that he's here on, you want to first determine whether his J-1 requires a 2-year residency requirement in his home country. If he requires a 2-year residency, meaning that he has to go back to his home country for 2 years, you want to try and get a waiver of that requirement before you can apply for him. If it doesn't, then you're fine. Okay. So hi, Eve. Eve says, I'm in the U.S. on a visitor visa. How can I go about staying in the U.S.? Can I apply for citizenship, a green card, a residency? What are my options? Hey, Eve, I mean, I guess you can shoot your shot. There's no harm in trying, right? Well, so the answer is, that's not how it works. Something has to qualify you for a green card. Being here on a visitor's visa does not qualify you for a green card. So the first step is, you being here in the United States, on a visitor's visa, do you have family members? Do you have immediate family members that can petition for you? For you as a B1, B2 visa holder, the people that can immediately petition for you for an adjustment of status, after 90 days preferred, are if your husband or your wife was already here in the U.S. and they were U.S. citizens, you had a child that was over the age of 21 that's a U.S. citizen, or yeah, that's it for you. Because I'm assuming that you're over the age of 21, so your parents won't be able to. So those are the only people that can petition for you for your green card. And then you don't just jump to citizenship if you were not born in the United States or you didn't derive citizenship from your parents by birth. Usually, you first have to get a green card. Once you get a green card, then after a few years, you can file for citizenship. So that's kind of how it works. Debbie, I see you want to ask a question, but it is blank, so I can't really see the question. All right, let's see. Okay, so this person on Facebook says, if you fill an I-300, what do you mean? Do you mean like an I-130? Is that what you mean to say, Ruth? Do you still have to pay another money? And then afterwards, your status changes to I-360. Do you still have to pay another money on your adjustment of status? So I'm not really sure what you're asking, but I'm going to use this to make an assumption that you're asking if you completed an I-130 and now you're changing to an I-360, do you have to pay money for adjustment of status? So this is a good question, and I hope to provide clarity for you. Adjustment of status is not an I-130 or an I-360. Adjustment of status is an I-485. So as long as you never filed an I-485, you must pay the I-485 fee or get approved for a fee waiver due to hardship in paying that fee. Now, if you already have an I-485 that you paid for, and that case is still pending, and now because of whatever is going on, in your marriage, you've chosen abeyance, which is what we call it, where you're basically saying, okay, don't make a decision on this case. I'm switching around my petition. In that case, there are many times that you can capture that fee and capture that application and merge it with the I-360 and remove the I-130. So hopefully that answered your question. Okay, Eve says, got it. Thank you. Debbie says, no question, just love your work. Thank you so much, Debbie. I'm so appreciative. Let me see if there are any other questions on TikTok. And if not, I will So I'm Zobia. I would recommend you definitely give me a call. Let me see what you've received and where you are in the process. My phone number here is 407-995-6567. And also, if you guys are international and you want to just send us a message on WhatsApp to see if you can schedule a consultation, that's 404-333-8751. Somebody says, "Hi, I'm from the Bahamas. What's the best way for me and my son to move to the United States to stay legally?" Honestly, the best and the easiest way is through a family-based adjustment of status. If you don't have a family person, then I don't know if you are inclined to be a student. If you want to be a student, you can certainly apply to a school here. If you get into a school, you can definitely apply for an F1 student visa. Let me see what other ways. And or then if you have like, maybe you have some skills, like especially in the STEM field, like you're a doctor or nurse, you can also look into like EB3s, on EB2s, or if you're a person of national significance, you could look into EB1s. So those ones are based on your skills. If you're a non-skilled worker, it may take a little time, but if you can find an employer that's willing to sponsor you in the EB3 category as a skilled or non-skilled worker, but they have to be able to sponsor you. So not just that they want to sponsor you, they have to show that they can financially sponsor you and pay you living wage. If they can do that, that's also an option for you. Okay. Let's see. What else? Okay, I think I got, okay, no. Mike says, I called your office last Wednesday. Let me see. I spoke to a gentleman who gave him a brief. He said someone will call me the next day. So Mike, send a text to 404-333-8751 and let us know what you called about. So we'll see if it's something that I can assist you with, and then they'll call you back to schedule a consultation. Usually, if they didn't schedule for a consultation immediately, it's something they're probably checking to see if I'm taking new cases on that matter. Okay. And then you can just let them know that I said that you should send a text there for them to show it to me, to let me know. Okay. So Chani Fendi, girl, I do not even know how to pronounce this name, so I'm not even going to bother. Thanks for all you did and still doing. As U.S. Army member, how long will it take to be approved when I apply for my wife and my daughter? Still the same timeline, unfortunately. If you're, U.S. citizen petitioning and your wife and your daughter are, well, is this your biological daughter? Because, depending on your child, the you applying for your child might already have citizenship by birth. So it depends. But for your wife, same timeline. So Gail says, if someone receives an RFE, is this always bad? Such should the person be worried? No, it's not always bad. Sometimes a request for additional evidence is really just that. Like, sometimes, I'll give you guys examples of sometimes the kinds of RFEs we get. Like sometimes it could be saying, this passport pictures are not clear. Send us a new passport picture. All right. Or sometimes it could be saying, we're not able to calculate your income based on what you've submitted. Send us a new tax transcript. Or it could be, we're not able to, this tax transcript is not signed. Send us a new one. Or sometimes, you don't submit stuff. You don't submit, a lot of people that try to do this themselves think it's really all about submitting a form. As I myself or many good attorneys will tell you, immigration is about packaging, putting you together in a package that shows that you should logically be approved for status in this country based on USCIS own laws and their own rules, because sometimes you have to remind them of their own rules and their own laws. So it's really not just about a form. So if you submitted something and submitted the bare minimum of evidence, sometimes that affects the case. And that's when they'll send you a request for evidence also saying, we don't have enough evidence to prove a bona fide marriage. We don't have enough evidence to show good faith marriage. Send us this, that. So not all the time is it a bad thing. Now, if you go to an interview and you get annoyed, we call it annoyed. What that means is NOID. That's a notice of intent to deny. Now, that is when you should be worried, because you better have a really good comeback, to be able to overcome it. Can it be overcome? Yes, but it better be good. Okay. Sandra says, my daughter did her fingerprint. She's 15 years old. How long before she's going to get back an answer? Same timeline as everybody else. The age doesn't matter. Someone says, my wife is a green card holder and I'm here on a visitor for 4 months. Can she file for me? And how long will it take? She's also waiting on her interview for citizenship at USCIS. Randy, so if you entered into the United States, and your visa, your entry, so your I-94 entry is still valid, because you're saying that you've been here for 4 months, meaning that I'm going to assume that because most average people get 6 months. If you got a 6 month, your wife can technically file for you now. She needs to do it now, because we don't know what's going to happen in July or August. So if she's going to do it for you, she has to do it for you while you're still in status. So between now to the next 6 months, you're still in status. So you want to try and do it now. Okay. If you need assistance with that, please call me 407-995-6567. Okay. Someone says, Roxanne says, good morning. If someone goes in on a second interview, spends 2.5 hours, and then leaves without still not getting an answer, is that a bad thing? Okay. So what she's talking about here, for those who don't know, is that, a lot of times if you go in for like a marriage-based case, can you guys see me on TikTok? I don't know why the screen looks blurry, or maybe I need glasses. I'm not sure. What she's asking, basically, sometimes when you go in for an interview the first time, usually if they don't believe the legitimacy of your marriage, they will schedule you for a second interview. So a second interview is really a time to be somber and really get your stuff together, because that is going to be the deal breaker. Usually you're not going to get a decision that day, because they're going to, sometimes they will tell you about your answers, what you got right, what you got wrong. So usually you're going to have to wait, for them to finish all their investigation, and they will send you the decision. So they could either approve you, or they can send you at that point a notice of intent to deny. If you rewind this video after you get off, I just talked about what a notice of intent to deny is about 5 minutes earlier. So you can watch that. Okay. Gail says, so does an RFE means that your case is stopped? Are you still able to travel with advance parole? So an RFE means that they're waiting for you to respond before they continue to the next process. But if you have advance parole, you can certainly still travel with advance parole. Just make sure you respond to the RFE, or have a lawyer that's in charge of responding to the RFE before you travel and miss the deadline. Okay. Rosani says, what am I supposed to expect after USCIS home visit? Oh, that's not good. Are you saying USCIS came to your house? So whenever USCIS comes to your house, that's not good. That's not good. They really, really don't believe you and are doing some investigation. I hope that you were able to pass the investigation ultimately. And, if you passed it, you'll get approved. If you didn't pass it, you'll get a notice of intent to deny. You always get a notice of intent to deny with an option to challenge what it is that they're saying to you. Okay. Okay. All right, guys, this was fun. I'm going to jump off now, but I enjoyed chatting with you guys. Am I going to be here next week, Wednesday? Okay, I'll be here. So for those of you on TikTok, I try to do this lives every Wednesday at 11. I know there are a couple of Wednesdays coming up that I have, client interviews. So I might not be able to be here at that time, but, log in, tune in. Would love to chit chat with you all. I hope you have a wonderful rest of your week, and let's go get some green cards and citizens. All right, bye. Have a great day, guys.